I probably need a mic. I rest the mic on my fat belly. Good evening, or good morning, or whatever. Happy Wednesday. We're going to go over docket 109 in the Decastro versus Abrams lawsuit. This is Defendant Kate Peters' opposition to plaintiff's second motion for contempt. I'm going to bury the lead. I don't know if anybody's even in here yet. I'm going to bury the lead, and I don't really know how to review this. I have a different standard of review for when a person writes something pro se in the federal courts, or when an attorney writes it. And I was under the impression, from what Ms. Peter was saying, Kate was saying in her in my Discord, that she wrote it with help from people. But I see that this is signed by Benjamin Wish. And that makes me think that FRCP, what is it? Rule 10? I'm going to guess 10. Form of pleadings. It's not 10. It's not 10. And I know you can't see what I'm looking at. Pleadings allowed, form, signing of pleadings and other papers. There we go. Rule 11. I was close. We're going to present, share screen, Rule 11, share. So every pleading, written motion, other paper must be signed by at least one attorney of record in the attorney's name or by a party personally if the party is unrepresented. The pleading was signed by Benjamin Wish. The paper must state the address, email address, and phone number unless a rule or statute specifically states otherwise. A pleading need not to be verified, yada, yada. Representations of the court. By presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating for it, an attorney or unrepresented party, which in this case there is an attorney, certifies it to the best of the person's knowledge, information, and belief, informed after an inquiry reasonable under the circumstances, not proper purpose, blah, blah, blah. But basically he's signed his name to it. And so I don't know if I should judge this as though it was Wish's motion or if it was Kate's. So I guess we'll get into it. We'll see what we see and we'll go from there. So no better place to start at than the beginning. If you're wondering, I'm scratching the ever-living daylights out of Siobhan because she is demanding attention. Defendant Kate Peters' opposition to plaintiff's second motion for contempt. Section 1, introduction. Defendant and plaintiff in counterclaim. Kate Peter, Ms. Peter, hereby opposes the second motion for contempt motion of plaintiff and defendant in counterclaim, Jose Maria Decastro, a.k.a. Chili Decastro, a.k.a. Delete Laws, hereinafter Mr. Decastro. Ms. Peter denies the allegations made in Mr. Decastro's second motion for contempt. I like that. It's short, it's sweet, it's to the point. Further, Ms. Decastro requests the court clarify its orders as to the behaviors parties are not allowed to engage in. Ms. Peter requests this clarification not only to allow her to better comply with the order, but additionally to hopefully prevent future frivolous contempt motions from being filed. I agree with that. I have a light bulb flickering above me. It stopped. One thing that you might not be aware of is that when I have this stupid thing on, there is a, I'm going to do this just so I show something else. All right, perfect. There is a webcam light that's just boom right in my eyeballs, just raping my face. So I have to have an overhead light on to kind of counteract some of it. It's wicked, wicked bright. So yeah, so she's asking to clarify the orders, and I think that's a good thing. Ms. Peter and Mr. Decastro have differing opinions on what constitutes harassing or otherwise inappropriate behavior. I believe that is correct. One thing in this pleading that I have seen, just having gone through it, is it's very light. I think there's only like 2 citations. I think there's only 2 citations in this thing. So it looks like it was written by a pro se litigant. So, yeah. Relevant factual and procedural backgrounds. On October 21, 2022, the court issued the following order, ECF number 33, which stated in its entirety that the court has reviewed the recent motions filed by each of the parties to this matter, ECF numbers 25, 27, and 30, and hereby orders as follows. Plaintiff and defendant are ordered not to engage in any threatening, harassing, illegal, or otherwise inappropriate behavior when engaging with each other or with any individual or entity that may have knowledge pertaining to this matter. Any contact with a represented party should be through their counsel. The parties are further ordered that despite the entry of this order, the hearing scheduled for October 24, 2022 at 12 p.m. will still take place, and all parties or their counsel are expected to attend. I don't know why Kate and or Wish decided to include the entire order. They could have just said the court ordered and then started off here through there. But okay. On October 24, 2022, the court further ordered that ECF number 43 reminded parties of the previous order, stating in part that the parties are reminded of their obligation to comply with the court's order on October 21, 2022, which forbids all parties from engaging in threatening, harassing, illegal, or otherwise inappropriate behavior with respect to the other parties in this lawsuit. See ECF number 33. The parties are further advised that failure to adhere to the order may result in, among other possible sanctions, monetary fines. I don't know why everybody is suggesting that this is an order. Now, in PACER, this shows up as a court order. Yes, there is alcohol in this beverage, and no, I'm not wearing pants. This does state that it's an order in PACER, but this does not say the parties are ordered to do anything. They're reminded of their obligation to comply with the court's order. CCF number 33. Parties are advised their failure to adhere to that order, ECF 33. So I don't know why this is in here. Doesn't make sense to me, but I'm dumb and I don't know what I'm talking about. On November 2, 2022, the court once again addressed the issue of the parties' conduct surrounding this litigation, ECF number 51, stating in part, to be clear, the parties are not to destroy or otherwise compromise any evidence relevant to this case. That sounds like a court order. And then it says, further, the court strongly recommends, a strong recommendation, no matter how strong the recommendation is not an order. It's a recommendation. Order is a word, and recommendation is a different word. And if you look up the definition of the word order in the dictionary, you'll come up with a completely different definition than if you look up the word recommends. That the parties not harass, disparage, or otherwise act unkindly to each other or any potential witnesses in this matter. It is the suggestion, again, suggestion versus order. They have different meanings. I am going to assume that the court is not an idiot and uses the word order, like shall not, are not, strong language when the court is making an order. And recommends, suggestions aren't orders. It is the suggestion of the court that going forward, when faced with questions of conduct, all parties to this litigation and their associates harken back to the lessons they learned in elementary school about getting along with others, proper behavior, and cooperation, and act in accord with those lessons, hopefully without constant recourse to the court. On November 14th, 2022, Mr. Decastro filed a motion for contempt, ECF number 61, alleging that Ms. Peters' conduct in engaging with her YouTube audience in a live stream about the attempts of Mr. Decastro to bully and silence critics, wherein Mr. Decastro joined Ms. Peters' YouTube chat and proceeded to harass Ms. Peter. That is a sentence. That is a very long sentence. I would recommend breaking that sentence up. Ms. Peter filed a cross motion for contempt at ECF 71. On December 1, 2022, the court denied both motions for contempt. The court stated, in no uncertain terms, both parties have repeatedly engaged in inappropriate behavior towards one another, and the court will not single out one party for punishment where both are at fault. The parties are once again reminded that this is a court and not a kindergarten, and that the court expects the parties to act accordingly. Otherwise inappropriate behavior. I have stated many, many times that inappropriate behavior is unclear. And I think that this order right here, because it includes otherwise inappropriate behavior, is not sufficiently clear to support a court finding of contempt. All right. I didn't see any questions there on a quick glance. On January 16th, 2023, Mr. Decastro filed a second motion for contempt, ECF number 103, alleging that Ms. Peters' critique of a website, www.torturecuffs.com, published by Mr. Decastro, violated the court's orders, ECF number 43, ECF number 33. He said it violated 43 and 33. There's 33 and 43. He didn't say 51. 43 again is not in order, but okay. And request the court hold Ms. Peter in contempt of said orders. Argument A. Ms. Peter has not violated the court's orders. Again, straightforward, to the point. Interesting title. I wouldn't have used that. First, there better be a second. There better goddamn well be a second. There is no second. Oh, I hate that. I hate that. Ms. Peter understood these orders to pertain, these orders, ECF 33, 43, and 51, pertain to conduct engaging with one another within the context of the lawsuit. ECF number 33, plaintiff and defendants are ordered not to engage in any threatening, harassing, illegal, or otherwise inappropriate behavior when engaging with each other. Three ellipses, fine. There's a fourth one. That's too many periods. Since the onset of the litigation, or since the onset of the lawsuit, Ms. Peter has not engaged with Mr. Decastro, nor answered the emails sent directly to her by Mr. Decastro or any of his purported associates. She's not engaged him since the onset of the lawsuit. She's not engaged him nor answered any of the emails sent directly to her by Mr. Decastro or any of his purported associates. I remember her yelling at him when he was in her chat. What one was that? Oh, the quarter man, half man, whatever. He was in her chat and she was directly addressing him. I think that's engaged. So this says Exhibit 1. All right. So just to keep these fresh, we're going to stop the screen. We're going to present, share screen, and we're going to look at, I think that's number 1. That's Exhibit 1. All right. Exhibit 1, info regarding info request. What is that? From delete laws to delete law. From delete laws at gmail.com to delete laws at gmail.com. CC info at masshole report. What are these dates here? 11/19, 11/20. $11/19. Sorry, just trying to get out. I don't want to read these backwards. All right, so on from info at massholereport.com. So she's responding to this. Okay. So at some point, these timestamps are weird. Wackadoodle. So I think she's responding to this. All right. So I'm going to go with this. Oh, I get it. This is on her side. So she got this Eastern time at 4:17, and then he got it sometime in the West, some Pacific time zone, maybe. All right. So Matt, who the fuck is Matt Decastro? Where did we get a Matt Decastro from? Jesus. Chili just likes to make people up. Dear Miss Peter, Mr. Zane Kane asked me to email you before he filed suit against you next week. Oh, yeah. This isn't Chili. Telling people he's going to file lawsuits against him ahead of time. That's totally not Chili. No, in this case, it's Zane Kane. Zane Kane asked somebody by the name of Matt Decastro. He feels uncomfortable contacting you directly. Zane Kane does. Okay. He plans on naming you in his harassment action with significant monetary damages. Just so everybody's aware, the amount of damages that you claim in your lawsuit when you file the complaint are really only significant if you get a default judgment. If you get a default judgment, you are limited to the amount of damages that you claim in your complaint. That doesn't mean you'll get all of those damages. That means you're limited. That's the top end. You still have to prove. There's going to be a prove-up hearing of some sort where you have to prove damages. Even though they never showed up, even though you get a default, you still have to prove the damages. That's called a prove-up hearing. And so the only thing that the monetary damages signify is the theoretical limit on how much you can recover in a default. If it doesn't go to default, then you get whatever you get at trial or settlement. So the amount of money that you state in the complaint is only relevant. I guess for federal court, if you're going to do it for federal court, it might help you to establish the minimum jurisdictional amount for diversity jurisdiction. But other than that, the only way it helps you is for default judgment. The majority of the damages were done by the Kate's Tea Party signs and other vandalism that occurred at his shared residence. So unless you can show that Kate caused the Tea Party signs and or other vandalism at his, and that he owns these residents or has some ownership interest in them or some responsibility for them, he won't recover. He plans on naming you directly. Ooh, I'm going to name you directly. And any John Does to be substituted if it comes to light that there were other people responsible. If you were not directly involved and can name the people that are responsible or provide information on them, Mr. Kane can name those people and leave the John Does for anyone else that the discovery leads to. Please let me know how you wish to proceed by Monday. Discovery. I figure we'll take a slight detour. It's his nephew. Okay. We'll take a slight detour. The discovery isn't like some all-encompassing thing. You're limited in discovery. Like in California, you're limited to either evidence that's admissible or is likely to lead to admissible evidence. Calculated, I think, is the word they use, calculated to lead to admissible evidence. It's not a free-for-all. Well, let me rephrase that. It should not be a free-for-all. If you're going up against an attorney or someone who's not stupid, they're going to object and say, like, this isn't relevant evidence or likely to lead to relevant evidence. So, and another thing is that another oddly limiting factor in discovery is if you ask people to produce documents that are directly going to show them to be at fault, they're going to be hesitant to turn those over. Sometimes you have to use a little bit of finesse, a little bit of, let's say, backdoor action, not meaning the pun, alternate means of getting that information. That's why there are multiple methods of discovery available, not just from parties, but subpoenas. And that's why even like for parties, you have requests for production of documents, you have interrogatories, you have requests for admission, you have depositions, and a skilled attorney is going to use all those things to get to the point where he can say either that the person is lying by not producing the relevant evidence, or he could basically get the person to produce the evidence because it becomes very clear that by giving contradictory or misleading or responses that have holes in them, that it's just apparent that there is a gap in the evidence, as it were. So I don't think that Chile, I've seen Chile's discovery, and he asks some really stupid fucking questions for discovery, and he's not going to get the kind of results that he's hoping for. People aren't just going to shit out the information he wants. They're going to construe things narrowly. They're going to object, etc. And he's going to have to convince the court that his discovery isn't just a fishing expedition, that it is calculated to lead to admissible evidence. So, I mean, good luck to him. So this is from info@massholereport.com. I believe this is Kate's email address. I believe it might be a community email address. Decastro Matt 661 at gmail.com. So Kate responds, nobody did anything to Zane Kane. I understand that they fabricated evidence of a made-up incident. This has already been ruled on in New Hampshire as well as Massachusetts, and Arizona has no jurisdiction over me. That is a hell of a long sentence. Don't contact me again. And then I guess Matt forwarded it to Chile. And then Chile responds, is that a penguin? That's a penguin. That's a penguin. Chili figured out how to make a penguin. Chili Willy. Chili Willy. My name is Chili Willy. I wonder why I'm chilly all the time. I get it. I get it. Oh, God, I'm dumb. That took me forever. All right. So then Chili responds, Miss Peter, penguin, this is an information request. Additionally, this is an attempt to enter mediation and end this war. Kate. We started from Mrs. Peter, and now we're at Kate. Let me be clear. My cousin, who is also a legal scholar, quote, Matthew Decastro. Instagram. There we got a senior tax consultant. Director of certified personnel. BMX museum. Hatcha Miasma Dragon Egg. Matthew Decastro, legal scholar. To the Googles. Nothing for it. The first result is Jose Maria Chile Decastro, thepublicdocuments.com. A public document repository pertaining to Jose Maria Chile Decastro, a controversial name in social media and self-proclaimed constitutional legal scholar. All right, so I know you couldn't see any of that, but there you go. So we got Matt Decastro, a legal scholar, reached out to you in an attempt to amicably resolve the stalking and firing that you caused by stalking me and my friend through your Discord account. Caused serious financial and emotional damages to Mr. Kane. Are we talking about Chile or are we talking about Zane Kane? That sentence didn't make any sense. Why can't people just write short sentences? Why can't we do that? Why can't we just write a short sentence? The information request is that you reveal who the stalkers were/are so that we can pursue them and not you. Kate, every bad person you host will be pursued and dealt with through the court. Mrs. Peter, pick a goddamn name to call her, Chili. For fuck's sake, is she Kate or is she Mrs. Peter? Are we being formal or informal? Mrs. Peter, should you choose to ignore, deflect, or rationalize away this simple information request, it is 100% that you will face a lawsuit this week. 11/19/22. Your 100% might be a little high. Your odds are a little high there. I would bet against that. If you're giving 100% odds, I'd bet against that because apparently it didn't happen. TBH. And it's not a simple information request. It's also an attempt to mediate and end the war. So there you go. You know, nothing like mediating with someone when you have nothing to offer them. TBH, after I learned of the horrible things that you've been doing to people for years and years, your constantly unfair and often unscrupulous dealings with people, I've decided that your misdeeds are worthy of my attention. Is this a simple information request? I feel like we've moved on from simple information request. I feel like now you're shitting on her. And you're telling her that you're going to go after her. It's not a simple information request. I don't get it. I mean, did your meds kick in there? Like, what happened? Did you write one sentence and then come back an hour later and write the next and not read any of the previous sentences? Did you forget where you were? Did you go out and smoke a doob between one sentence and the next? Therefore, what is this formatting choice? Each sentence is its own paragraph. Okay. No, sometimes you have two together. Therefore, and what's with the weird capitalizations? You can and you will reveal to me. You can and you will reveal to me and my team who stalked Kane at his job in New Hampshire. Or I will organize Well, I already have organized and fund the Arizona lawsuit against you. Fucking okay. Oh, Jesus. So Zane was stalked at his job in New Hampshire by Kate, who lives in Massachusetts. And Chili thinks that Arizona's going to give a flying fuck about what happened. I'm going to go with probably not. But you go ahead there, buckaroo. You have led a poor life, and you have hurt many people whom I have spoken with. Like, what does that have to do with the price of tea in China? Regarding your lifetime of pattern, why is the T capitalized? Regarding your lifetime pattern of unscrupulous behavior, it must end and you must change. It must end and you must change. We know that change is a slow and difficult process. Therefore, because you exemplify an obtuse and reprehensible life, you must be dealt with through the court system. Is this an information request? Is this mediation? Or is this a giant fuck you, I'm going to sue your ass? I'm lost. We've had like 10 paragraphs. I don't even know what the fuck we're talking about anymore. Therefore, I give you my solemn promise. Why do I think Goku is going to go over 9,000 power or whatever the fuck it is? Therefore, I give you my solemn promise. I will see this through to the very end, Sensei. You cannot fathom my resolve. No one fucking cares about your resolve, Chili. So he's going to, it's a simple information request. It's a attempt to mediate. It's a giant fuck you. And it's, I'm going to litigate because I'm going to see this to the very end, through the very end. The many faces of Chili Decastro. We are requesting the name. We're back to requesting stuff now. It wasn't you will anymore. Now it's back to requesting. We're requesting the names of the people who went to Zane's employer's home in New Hampshire. You have until Monday morning to reveal them, or there will be another lawsuit filed against you. Monday, yeah, we saw the Monday timeline. I mean, if at first you make a demand and it doesn't succeed, just write a longer demand, because apparently you didn't scare her with the first one, so make exactly the same threats again, just longer winded, and it's bound to work. Winning plan. Why didn't I ever think of that? I mean, I could have saved myself thousands of dollars just by making the same demand over and over again, repeatedly, ad nauseum. As a friend of mine would say, Chili's stupid. Reveal your trolls or face legal action. This is not a drill and the clock is ticking. Insert further catchphrases here. Regards, Jose M. Decastro. P.S. This is the first shoe. Another shoe will drop midweek. I'd wish you luck, but you wouldn't know what to do with it. You wanted my attention. You got it. Penguin. What a fucking idiot. That was exhausting. All right. So we're going to go back to this one right here. So I lost where I was. Since the onset of the lawsuit, Miss Peter has not engaged with Mr. Decastro, nor answered the emails sent directly to her by Mr. Decastro or any of his purported associates. And then either she didn't understand what she was saying in her sentence, or she figured she would just fucking prove that she's lying by attaching Exhibit 1, which shows that she did, in fact, answer the email sent directly to her by Chili, or at least by his alter ego, Matt. Because why wouldn't you? Why wouldn't you do that? Like, I mean, I'm guessing, and this is just a guess. I have no firsthand knowledge of any of this. Oh shit, there's more. Oh shit, there's more. Sweet mother of God. So anyway, we already know that she completely effed herself because, well, not complete. I mean, this whole thing was stupid. So I'm thinking she just wanted to show the court this. Like maybe she thinks the court's going to read through all this. The court isn't. But let's do this. I guess let's do this. I mean, in for a penny, in for a pounding, right? So the next day, Chili. Let me check something here. November 19th was a Saturday because, of course, you want to make demands on a Saturday when you're sure that the person is going to receive them and have the time to respond to them, to have them due on Monday. So he sends an email Saturday and then he follows it up on Sunday with this. Kate, just to clarify. And then he quotes. Nobody did anything to Zane Kane. I understand that they fabricated evidence of a made-up incident. This has already been ruled on in New Hampshire as well as Massachusetts, and Arizona has no jurisdiction over me, end quote. Let me help you out with your reply to my cousin and pray you will enter mediation. See, one thing that you never want to look in a mediation is weak. In a negotiation, you never want to appear weak. Chili initiated it. Kate said no. Chili came back without really changing his offer at all, just reiterating his offer. Got no response, and then made another attempt to, I'm going to guess he's going to reiterate his offer yet again without changing. He's not moving anywhere. He's just beating his head against a door frame thinking that that's going to change anything. It's not, dude. If your tactic isn't working, change your tactic. You're obviously getting no traction with this. It was like sending me emails. You got no traction with it, and I got videos to make out of it. Like you're not gaining anything. Just stop. Let me help you out with your reply to my cousin, wink, and pray you will enter mediation. 1, yes, you did to a lot, one word a lot, to Zane. Yes, you did to a lot. You did do a lot to Zane. You doxed his residences in Massachusetts, New Hampshire, and Arizona. Zane seems to be doing pretty well if he has residences in 3 states. And phone books do the same thing. They put out your address. It's not doxing. Like, how did that damage him? It didn't. Nothing has been, quote, ruled on, end quote, because the issue has not been properly litigated on. Well, there were judgments that issued from it, denying your petition for relief and denying Zane's petition for relief. So, yes, judgments have issued. No, it hasn't been properly litigated because you're a fucking idiot, but it's been litigated and there's been judgments. So you will not get a Massachusetts restraining order hearing to stop our lawsuit out of Arizona. To stop our lawsuit. Are you representing Mr. Zane Kane out of Arizona, Mr. Chili? That'd be interesting. You, I mean your AZ lawyer, can submit the mass RO hearing to the AZ courts. However, the court will not dismiss the lawsuit based on RO hearing out of Massachusetts. You know, really, what you would do is you would ask the court to take judicial notice of the Massachusetts findings, and she'd probably point out to the Arizona court that the court doesn't have subject matter jurisdiction or personal jurisdiction over her, and also point out to the court that there is an ongoing lawsuit, well, not between Zane and Kane. So So Zane Kane should have brought all of his eggs at once, all of his potential actions at once. I'm going to assume that Arizona doesn't like to piecemeal it. So Zane Kane, he shot his wad and lost. You can't just keep relitigating the same things. So yeah, it probably will be res judicata. What was that? Issue preclusion. And there's also going to be a huge personal jurisdiction, and there's probably going to be subject matter jurisdiction issues too, because what does the Arizona have to do with it other than the fact that Zane lives there? None of the alleged actions take place in Arizona. And he has residences in Massachusetts, New Hampshire, and Arizona. I don't know that the issue of subject matter jurisdiction is particularly clear. He says 3, Arizona does have jurisdiction because you doxed. Is it somehow a tort to dox someone's car or address? We have jurisdiction. Is it I don't think so, but whatever. And we file in the morning. Oh, well, that was 11/21/22. I don't know. I haven't seen anything, but good luck. 4, you will have to hire an Arizona law firm. So start looking now. Why doesn't she start looking after she's been served? That's when I would start looking if I was her. But I'm dumb like that. That's weird. I'd like to avoid paying the $402 to sue you out of Arizona and California, $804 for both. I think the filing fee, federal court filing fee, I think it's $402 for federal court. It's $400. It's $350 plus $52 administrative filing fee. Now, California, I'll choose Sacramento County Superior Court, and we'll do warning jury scam. We will do where's filing fees? Departments, filing fees. I haven't looked for filing fees in a long time. I guess just take my word for it. California is $435 to file a, here we go, fees and forms. Fee schedule effective then. $435. I'm going to assume Arizona is probably also a different filing fee than federal courts. So if he's planning on filing in a federal court, the federal court is not going to allow him to maintain a lawsuit out of California in federal court and against the same party that he already has a lawsuit in Massachusetts against. It'd be a fairly simple matter for Kate to have her attorney in Massachusetts notify the court or pro hac vice someone in or whatever, or even have Kate just do it to file a notice that there's already litigation going on. I don't remember what 12B motion it would be, but the court would then just drop it so that Chile can add it onto his existing lawsuit in Massachusetts, or it would transfer it to Massachusetts. I don't know exactly how it would work, but federal court, you can't have two lawsuits against the same party going on. The court's going to be like, no. How about no? However, should you choose to ignore this prayer for mediation, I'll file versus you, or Zane will, in both states on Monday and Tuesday. This is not a game to me. This is not a game to me. You have affected the rest of my life in a negative way. Dude, like, you're letting this get a little too deep to you, bro. It's the internet. It's not real life. Turn off the internet or stop watching Kate's channel. Like, I will not tolerate it. I will not tolerate it. And I'll throw my entire being into getting justice for the unscrupulous person you are. He's going to get justice for Kate? Hashtag justice for Kate. Jill's going to throw his entire being into getting justice for the unscrupulous person Kate is. Justice for Kate. You can change, and I know you will. He just bounces back and forth between like threats, cajoling. He's fucking stupid. Stupid. However, I'm not waiting for that to happen. You will stipulate, or we will continue in court in 3 states. I give you my promise to that. How's that working out for you, Chili? Additionally, Kate, I hear you're at $60,000 in legal bills from your criminal case and my federal tort lawsuit. Imagine how much that grows when you have 2 new lawsuits. You messed with a legal scholar. It's really showing, dude. Pro tip: if you have to tell people you're a legal scholar, if it isn't just apparent by the quality of research that you do, then maybe, just maybe, it's not going to help by telling them. I mean, it's like walking around telling people you're a good person. You know, if you have to tell them, it means you're probably not a good person. Just saying. You messed with a legal scholar who has tons of legal help. Well, why would a legal scholar need tons of legal help? Why would they want? Who's helping? Who would help a legal scholar? I don't know that legal scholars like a thing, technically. I'd rather stop this and move forward with my life, and you can move forward with yours. Zane will file versus you in Arizona, and I'll file another one versus you in California this week. You don't get away with lying and defaming me. Nope. No, you do not. Like, and again, like, now you're filing this week. I thought it was Monday, bro. I thought it was Monday. What a fucking idiot. God, he's just painful to read. Maybe you were enjoying raising money from other people, and that gives you the limelight. I don't understand, to be honest. The dude made a video saying that he was like proud of his e-bagging. E-bagging, fine, call me an e-bagger. I'm proud to e-bag because I raise money for people, blah, blah, blah. I don't understand, to be honest. You've never been honest a day in your life, Chili. I'm trying to end this through strength and mediation. I guess you're just not strong enough, bro. If you were strong enough, you'd have been able to end it. I'm willing to stop now and begin mediation. I'd like to move on with my mission. And you can move on to being a better mother to the kids you have left at home. You know, if you're trying to mediate, one thing, helpful tip, helpful hint, mediating. If you're trying to mediate, one thing you want to do is not get the other person emotional. You don't want to elicit a strong emotional response against you, because people will go a long way. They will go a long way just to tell you fuck you. They will go out of their way to tell you fuck you. They will spend, like in Kate's case, $50,000, $60,000 to say fuck you. I mean, think of what you can do with $60,000. Kate, instead of doing anything constructive with $60,000, she shit it down a lawyer's throat just to say fuck you, Chili Decastro. And then you're like, you know what? You're a shitty mom. How about we settle? Holy fuck me. What's his name? Mark Abrams. He came into my Discord the other day, and he said that he believes that Chili is autistic, that he's on the spectrum, that he sees things in black and white. He doesn't really pick up social cues, much like Mark. Mark admits to being, he has Asperger's, something or the other, whatever that is. I only know it from South Park. I'm not a doctor. I don't even play one on TV. I'm not smart enough to be a doctor, but that might explain some of this inability to be able to write a coherent letter that doesn't bounce between cajoling, pleading, threatening, saying what you're trying to do, with sometimes like a weird sort of honesty that undermines your position. Like, I don't really understand anything about what's going on here. And the only thing I could think of is either Chili's on drugs, or maybe he is some level of autistic. I don't know. I don't know. He says, I can promise you this. My cousin, his legal scholar cousin, will help Zane all the way through. So if you're going to try to pretend it's your cousin, you shouldn't say that you are going to file suits. I'll file versus you in both states on Monday and Tuesday, right up here. You can't see my cursor, and I can't highlight it, but right about in the middle of the screen, under the I'd like to avoid paying you $400 or paying the $400 to sue you. It says I will file against you in both states. And now he's saying my cousin will help Zane all the way through. He can't even maintain a consistent lie. I don't want to speculate on that. I'll move on with what I'm doing next. And Maddie, it's so cute. His pet name for his fake cousin is that's cute. Will help Zane until you have to pay up for doxing him, stalking him, and ultimately costing him his job. And again, number one, there's no money in any of that. Just so you know. Good luck, have fun. Good luck, have fun. But if Kate spends all of her money on legal fees, then what? Then what? And you're this inept at just getting to a judgment. You're this inept at getting to a judgment. You're not going to be able to enforce a judgment. Like, you're just not. You're going to be so fucking wound up trying to enforce the judgment, and you never will. It's tough, especially enforcing out-of-state judgments. Oof. That's fun. That's a whole nother hill of beans there, buddy. That's sister state judgments, whole other hill of beans. You have until tomorrow morning to agree to enter into mediation. Again, it's the same fucking threats over and over again. I'll work with you on Zane's behalf in my own personal interest to stop all lawsuits and move into a peaceful and meaningful mediation. My stipulations are clear. Remove all the videos and my likeness from your page. I don't give a fuck if you apologize or not, so we can skip that. Lastly, enter into a private mediation. It's not publicized by either of us to compensate me, to compensate Zaner Zaner. That sounds like a medical condition. We've got this real bad Zaner. For you and your troll farm costing him his job, I give you my word on a publisher to talk about this communication publicly. Well, I guess Kate didn't give you her word. Dinner and mediation settle this out unless you do. I promise you on my life. I just want to end this and move on with my life, and you can do the same. Well, yeah, that didn't appear to go too well. So back to this. I'm sorry for the detour. A detour the judge is not going to take. I don't foresee the judge taking it. A law clerk might just giggle themselves, but really the only pertinent thing was she was saying that she had not engaged with him, and sadly saying I have not done something. Usually there's no exhibit attached, and if there's ever an exhibit attached when someone says they haven't done something, probably means they've done it. If someone says I have never masturbated, and then they attach an exhibit, what do you think's on that exhibit? The only time Miss Peter has engaged with Mr. Decastro is when Mr. Decastro joins in Miss Peter's live chat while Miss Peter is live streaming to her audience. So we go from I have not engaged with Mr. Decastro to the only time I've done it is this one time when he joined is when he joins my live chat. I haven't done it except for this time when I've done it. While dealing with Mr. Decastro in her live chats, Miss Peter remembered the admonitions of the court and abided by them. I haven't done this, but I did. I haven't done this, but I did. But when I did those things that I just said I didn't do, I promise you that I didn't violate court orders. Four of 9? Christ. Mr. Decastro claims that Ms. Peter violated this court's orders by broadcasting a, quote, live stream, end quote, on January 16, 2023, entitled, that should be titled, regarding the End Torture Cuffs Deception Marked Out debacle, which contained a live analysis and critique of a website published by Mr. Decastro, www.endtorturecuffs.com. Ms. Peter was reporting on news and giving commentary and opinion on that news through her YouTube channel, which is not, quote, engaging with, end quote, Mr. Decastro. Mr. Decastro is not obligated to, nor is he encouraged to watch Ms. Peter's YouTube channel. So it's good that she's remembering that she's in the I'm not engaging with kind of area here. Mr. Decastro seems to be under the mistaken belief that anytime Ms. Peter reports on his newsworthy antics or engages in the slightest criticism of his public website full of misleading and admittedly false stories, she wanted to point that out, or wished it, I don't know, that due to this court's order, Ms. Peter is not allowed to report on it or to give commentary and opinion on it. Ms. Peter is not under the impression the court intended to place a prior restraint on Ms. Peter's speech. I like that. Prior restraint is where a court says you can't talk about something. You'll see it a lot of time. Gag orders, they call them gag orders. They are, I talked about this the other day on my Discord. I'm assuming that's where Kate got it. In fact, with Delete Laws, with Mark Adams, I talked about it with him. They are presumptively unconstitutional because they have to be narrowly tailored, yada, yada. But what if Chili Decastro all of a sudden, like tomorrow, just declares that he's running for president? No one would argue that that's not newsworthy. And that's also politics. Politics, newsworthy politics, the highest level of protection. It's exactly the thing that the First Amendment was most specifically designed to address. And it has nothing to do with the lawsuit. So all of a sudden, what sounds like a narrowly tailored restriction all of a sudden isn't. So, indeed, if Ms. Peter is not allowed to, for any reason, report on Chili's newsworthy antics or to criticize, give commentary and public opinion about websites, that would include any potential campaign websites, right? Full of campaign promises. Full of campaign promises. And she would be able to say these are true, these are false, these are something that you get or something you can't get. So, yeah. Prior restraint, good argument. Probably Miss Peter, because I was talking about it the other day in my Discord. Indeed, the court said as much in the hearing on Miss Peter's emergency motion for hearing for status conference and invited the parties to agree not to mention each other on their respective channels. I remember that. If I remember it correctly, and I could be wrong because it's been a long time since I watched that. I think it was, I didn't record it. I didn't see a recording of it. I think I actually watched it live. The court suggested that the parties might want to agree to basically not mention each other on YouTube. And Benjamin Wish, Kate's attorney, said that he couldn't make that determination for his client. I think Decastro at the time said that that sounded good. Wish said he needed to talk to Kate. I think Wish talked to Kate, if I remember correctly, and Kate said, yeah, it's cool, let's do it. And then Wish communicated that to Decastro, and Castro said, fuck you, I've changed my mind, and declined, if I remember correctly. But yeah, one of the issues at that hearing was that the court acknowledged the court could not order them not to talk about each other. Ms. Peter was willing to stipulate to that deal, and Mr. Decastro declined, and he is now attempting to use a vaguely written court order to get the benefit of the deal he declined. Vaguely written, yeah. That's a problem. I mean, that's what she was alluding to. I think that's what she was alluding to up here with asking for clarification. Asking for clarification because it's vague. So perfect. And vague orders you can't be in contempt of because it's vague. Mr. Decastro alleges that Ms. Peters' accessing of the site was Mr. Decastro alleges that Ms. Peters' accessing of the site was somehow improper and amounted to, Jesus Christ, that's a tortured sentence. Mr. Decastro alleged Ms. Peters' access amounted to trade disparagement against plaintiffs' yet undisclosed technology launch. Further alleging that, quote, giant block quote. I'm sure all of this information is relevant. The court will need to read it. Further alleging that, quote, Peter acquired the private URL of a web application product. That's right. He's stupid. I forget sometimes. Owned by plaintiff Decastro that is being developed and funded, capital F funded, by Decastro with a third party. The web application product is currently unfinished and undergoing beta testing. Although Peter knew that the website was not live, Peter stated as fact that the website was complete and disparaged the quality of the site in a video over 2 hours long. This is false, as Ms. Peter accessed the site via the URL www.torturecuffs.com and viewed a publicly viewable and published website, indexed and searchable on the Bing search engine. See Exhibit 2, Bing search. Who Bings it? Bing it. Exhibit 2. She Bings it. She's a Binger. Who doesn't use Google search? Bing. Oh my God. I bet she uses Microsoft Edge too. But there it is. Post your story on handcuffs. Web https handcuffs.com. We see cops, security, government employees, and others get you put in cuffs for any reason. That's a great sentence, Chili. Most police don't know the laws in this country. Post your story, and there's Aaron K. It was October 21. All right. Sick. Bing it. Bing.com/videos. Bing it. All right. Where are we? Okay. Which contain no disclaimer nor indication on any page indicating the site was, quote, unfinished, quote, nor. This is Kate writing right here. This is not, this isn't Wish. This is Kate. Kate has these long, messed up sentences. Nor in beta testing. Were the site unpublished, as Mr. Decastro purports in his motion? Why wouldn't she just say Miss Peter would not have been able to access the site if it was unpublished, as Mr. Decastro alleges? Why do we have to have this tortured sentence? Why? Why am I on page 5 of 9? Another block quote alert. Mr. Decastro further alleges that Peter read several of the placeholder stories on the website in an attempt to track down the source of the placeholder images and say this fact the plaintiff was trying to pass these placeholder stories off as a real attempt to the deception with the most bullshit site. Oh, sorry, I was passing out there from the block quotes. Timestamp 318. Peter called plaintiff a liar. She called plaintiff a liar. What? Several times in the video and said that plaintiff himself uploaded the images and typed up the stories in an act of deception to con, grift, and benefit from supporters. Miss Peter was engaged in First Amendment protected activity, reporting on news and giving commentary and opinion about the news. Mr. Decastro admits the stories were untrue and every factual basis on which Miss Peter grounded her opinion and commentary, which she laid out in painstaking detail on the live stream, are uncontested. That feels like a long sentence. Mr. Decastro admitted the stories were untrue, period. Every basis on which Miss Peter grounded her opinion and testimony were uncontested. It is reasonable for Miss Peter. Clearly, Miss Peter had the opinion that Mr. Decastro was lying. I mean, it doesn't say clearly, but it means clearly. It is reasonable for Miss Peter to have the opinion that Mr. Decastro is lying when he. Oh, I guess not. Maybe. Okay, I'll take that one back. Mea culpa. I take that one back. That wasn't it clearly. It is reasonable for Miss Peter to have the opinion that Mr. Decastro is lying when he publishes a website full of stock images and fake stories. Miss Peter's commentary was not defamation nor harassment, as her opinions aren't facts or defamation, and nothing Miss Peter did fits the elements of harassment in Massachusetts or federal law. Okay. So her commentary wasn't defamation or harassment, as her opinions aren't facts or defamation. I have no idea what she's trying to say there. And there's a weird formatting thing. I have a feeling that there was a sentence or two sentences going on that didn't get finished. I think someone was probably rushing or didn't proofread. I think he's trying to say that the commentary wasn't defamation or harassment, as opinions aren't fact, and you need facts for defamation, and nothing Miss Peter did fits the elements of harassment in Massachusetts or federal law. I don't know if the court's going to take the time to parse that one out. The stories featured on the website www.endtorturecuffs.com appeared to be fabricated and implausible, and Mr. Decastro admits they are fabricated. Why don't we just say Mr. Decastro admits the stories on this website were fabricated? The images were showed through Google reverse image search to be taken from other sources, mainly reviews for products intended to treat psoriasis and news stories relating to the 2023 torture of Belarus blogger Roman Protasevich. The images were taken from other sources, mainly for products intended to treat psoriasis. But okay. By admitting in his motion that the stories were clearly fact. By admitting in his motion, the stories were fabricated placeholder stories, and the placeholder photos taken from outside sources, Miss Peter could not be engaged in defamation, as truth is a defense. That's another weird sentence, but okay. Furthermore, Ms. Peter did not post anything to Mr. Decastro's website, fake stories or otherwise. Ms. Peter did indeed speculate that Mr. Decastro's website would attract satirical tales from his many online detractors, but at no time indicated any involvement or even that such a thing had occurred. And Mr. Decastro has offered no evidence to support his claim. In fact, Mr. Decastro unpublished the website almost immediately after the live stream. What does that have to do with anything? I don't even know why that's in there. Oh, maybe she's trying to say that that he understands the difference between published and unpublished. I don't know. Mr. Decastro's allegations that Miss Peter, quote, literally stalks me on Discord, tracks my business operations and locations, and streams any videos I make on back channels are likely untrue and without merit. And Mr. Decastro, in his complaint, offered no evidence or even specific examples of such alleged conduct to support his claim. That's a long sentence. I would have made it in two. Indeed. Why do we have these indeeds? Why do we need these indeeds? Why just skip the indeed? Kate, you love your indeeds. Stop with the indeeds, Kate. They're too much. Mr. Decastro doesn't identify what statute, either Massachusetts, federal, or otherwise, from which he identifies his definition of stalk from. Ms. Peter has not stalked Mr. Decastro under Massachusetts law or federal law and lacks the ambition or need to research the other 49 states to determine if mentioning someone in Discord meets the definition of stalking. I like it. A little cheeky, but it makes a point. A little cheeky, though. Probably don't want to do too much of the cheekiness. Mr. Decastro appears to be just throwing words out at random to see if any accusation will stick. Mr. Decastro is just throwing words out at random to see if any accusation will stick. Again, a little cheeky, but probably not uncalled for. Ms. Peter denies Mr. Decastro's assertions that Peter knows that my future endeavor website is coming soon, and she obviously knows the stories were also not real. Nothing on the website stated the stories were placeholders. There was no lorem ipsum text, but actual stories with plots revolving around injuries sustained from handcuffs. I feel like feel like we're going over the same territory that we went over with the what's the dude's name? The weird Protasevich. I feel like this paragraph and this paragraph are probably duplicates or the same thing written twice. Maybe by two different authors. I don't know. They're different, but they're the same. But the images of wrists on which cursory inspection appeared to be damaged from handcuffs. The website was published and searchable by search engines. Bing it. There was no password protecting the website from viewing, no paywall, nor was there any other means of making the website private. There was no disclaimer or notification to site visitors that the site was, quote, under construction or, quote, in beta testing. And the stories and photos publicly featured on these sites were placeholders intended for beta testing of layouts and features. Ms. Peter didn't believe that the stories were intended to be, I think this probably should be a period. Ms. Peter didn't believe the stories were intended to be anything other than deliberately manufactured and misleading. Any opinion as to Mr. Decastro's motives were based on known facts as stated in the live stream and above in this opposition. They do appear to be like duplicate kind of competing paragraphs. They appear to be written by different authors, but I'm guessing on that. One has Kate's speech, one has somebody else's, but I don't know. Ms. Peter acknowledges that her public speech contains language that is critical, harsh, expletive written, and at times contentious. See, like this paragraph was written by someone, and then this paragraph was written by Kate. I don't know if Wish is getting in there or someone else. I don't know what's going on. And at times contentious. She loves to use this. I mean, I think she takes great pleasure that her public speech contains language that is critical, harsh, expletive written, and at times contentious. Because I've seen that exact sentence before somewhere. None of the speech alleged in Mr. Decastro's motion amounts to speech that would meet the definition of, quote, threatening, end quote. None of her speech would meet any statutory definition of harassment. None of the statements Ms. Peter made were illegal under any Massachusetts or federal statute. And Ms. Peter is unaware of any other jurisdiction with power over her speech on YouTube that would apply to her speech and is enforceable in United States federal courts. While Ms. Peter acknowledges that her speech may be perceived by some as, quote, otherwise inappropriate behavior, end quote, she does not herself consider it to be so and lacks a clear guideline as to what otherwise inappropriate behavior means. If it means prior restraint on her speech, Ms. Peter would contend that it violates her First Amendment rights to freedom of speech and freedom of the press. Standard of review. Mr. Decastro stated he was seeking criminal contempt in his motion. He did, 18 U.S.C. something or the other, but then set forth the standard of civil contempt in his memorandum of law. Ms. Peter assumes that Mr. Decastro intended to allege civil contempt. The elements of civil contempt are well established. To prove civil contempt, a movement must show with clear and convincing evidence that 1, the alleged contemptor had notice of the order, 2, the order was clear and ambiguous, 3, the alleged contemptor had the ability to comply with the order, and 4, the alleged contemptor violated the order. This is the part that I have been stressing. See Hawkins versus blah, blah, blah. While Ms. Peter had knowledge of ECF numbers 33, 43, and 51, the orders are not clear and unambiguous. Ms. Peter assumes that, quote, harassment has a legal definition, and presumably the one the court is using is the Massachusetts definition, either criminal or civil, but it's not clear. Same with threatening, where Ms. Peter assumes but is unsure the court is using the federal definition for a true threat as defined in Virginia v. Black, as statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. While illegal is clear, quote, otherwise inappropriate behavior, end quote, could encompass using a salad fork to eat fish at a fancy restaurant. Is there a fish fork or something? Do you not eat fish with a salad fork? I don't know. I eat with my hands whenever I can. The order is completely unclear. Is it completely unclear, or just parts of the order unclear? Dramatic hyperbole, a Kateism. Kateisms. Miss Peter assumes justice for Kate. Based on the court's suggestion, that was a callback, that the parties stipulate to prior restraint at the emergency hearing for status conference that the court did not intend by its order to impose prior restraint on Miss Peter and prevent her from reporting the news as it pertains to Mr. Decastro and or to offer commentary and opinion about those news reports. Valid assumption. Miss Peter has made every attempt to comply with the order based on her understanding of the order as augmented by the discussion the court had with Miss Peter's counsel and Mr. Decastro at the emergency hearing for status conference. Ms. Peter understood that she was not restrained by the court from discussing Mr. Decastro's newsworthy exploits and giving commentary and opinion about those exploits. Mr. Decastro has apparently come to a different conclusion as to the meaning of the court's orders and appears to believe that anything Ms. Peter says that Mr. Decastro doesn't like is, quote, harassment, end quote. It does appear to be that way, although that sentence appears to be a little clunky. Again, I don't know if I'm criticizing Kate or Wish. Finally, Mr. Decastro has failed to allege with any amount of specificity how any of the actions taken by Ms. Peter amount to, quote, threatening, harassing, illegal, or otherwise inappropriate behavior, end quote, that occurred, quote, when engaging with each other, end quote. Ms. Peter has not attempted to engage with Mr. Decastro and has only responded to him when he directed questions and comments to Ms. Peter in her live streams chat. So the distinction is she has not attempted to engage with him. She's only responded to him. That might have been a better clarification up at the beginning when she said that she hadn't engaged with him. Even when responding to him there, Ms. Peter did not threaten Mr. Castro, harass him, engage in illegal activity, or engage in otherwise inappropriate behavior based on the nature and location of the interaction. That's a good point. Conclusion. Thank sweet baby Jesus. For the foregoing. For the foregoing? For the foregoing. For the foregoing. For the foregoing. For the foregoing. Ms. Peter respectfully requests that this court deny Mr. Decastro's second motion for contempt. Additionally, Ms. Peter respectfully prays that the court clarify its preceding orders for the benefit of the parties. Respectfully committed, Kate Peter by her attorney, certificate of service. And then this is what I noticed. I'm going to do this 200%. 2 hundos. Share this tab instead. I just found that button, by the way, and it's amazing. You need the certification that they attempted in good faith to resolve or narrow the issue. Now, the court has waived this, but they still need the certification saying that they waived it. And there is also need to file affidavits and documents. She needs to attest to these particular exhibits. I have to pee so bad right now. She needs to attest to them. There should be some sort of declaration, affidavit. The way Chili does is he puts a declaration here that the foregoing is true and correct, blah, 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 under penalty of perjury. And I'm surprised that's not included, but there you go. Anyway, I have to pee like a racehorse. And so thank you very much for watching. Sorry, I'm not going to stick around and answer questions, but ask them in the comments. Have a great night.